Good morning. For those of you who are already on board, I am just going to wait a couple of minutes to let anyone who isn't quite as prompt as signing in at 11 o'clock to come and join us. But whilst we're doing that, I'll just do a very short introduction. I was pleased to see, as was Ed, that quite a few of you on the list of delegates know us already, and a big welcome to those that do. I'm not going to shout you out individually because there's too many of you, I'm glad to say. And for those that don't, of course, very much welcome as well to join us in this webinar. A little tiny bit about us. I've spent 30 odd years now doing personal injury work and 20 odd years doing clinical negligence. Ed has a similar practice in both personal injury and clinical negligence, and a few years extra ahead of me in terms of the time he spent on each of those fields. He also, of course, has the magic letters after his name, and Ed is going to be 10 years of silk as of next year. So congratulations to him for that. As you can see by his very natty headphones, he also has a sideline as a helicopter pilot, and he's dressed for that today. Seriously, he has a technical issue that requires the headphones, but I hope it won't detract from what he has to say. We both agree that Swift and Carpenter really does seem to raise more questions than it gives answers, and for a judgment that everybody's been waiting for with bated breath for months, it really does lead and leave us all in a lot of confusion. There is a Q&A button on your screen. I think in reality, we probably won't have time for any questions, but if you have something burning, do use the Q&A button. Don't try and use the hand up or anything like that, because that won't work. And also, I will be ending. Ed has taken the absolute main part of the role and is dealing with Swift and Carpenter as is appropriate given his seniority. I will be at the end, just coming back. For those that know me, I'm really a defendant man most of the time, and I'm just going to be coming back with a short discussion of some of the things that defendants might do to save themselves money on these claims. But without more ado, I hand you over to Ed, who is going to take you through Swift and Carpenter and do what he can to try and allay the confusion that the judgment seems to have wrought. Thank you.
Thanks very much, Angus, and welcome to everybody. I'm tempted to say this is your captain speaking. I think we should expect a little bit of turbulence over the next 30 to 35 minutes as we go through this judgment. Yeah, somewhere buried in my laptop is a setting that will explain why it is that I have to wear these headphones in order for you to be able to hear me rather than the other way around, because that's apparently how it works with my system at the moment. Anyway, there we are. Such are the joys of the new technical world in which we live. So the purpose of this talk is to look at this judgment and to go through it in summary and try and explain it, and then look at its practical application and deal with one or two of what I've called discussion points. So we're going to start with what we were all hoping for. I mean, those of us who've been practicing in this field over the last few years, I think, were perhaps legitimately hoping that once an accommodation claim case got up to the Court of Appeal, a solution could be found that would be essentially one size fits all, something that we could all understand, we could apply simply and clearly, and would make the calculation of possible damages in any future claim easy both to do and to understand. And I think it's probably right that the Court of Appeal thought that that's what they were going to be doing. And they recognise this in various passages of the judgment that they've just produced. Lord Justice Irwin, at paragraph 78, said, perhaps more than in any other field of litigation, and he was referring to personal injuries litigation, disputes are resolved by negotiation and settlement. There is the strongest possible need for clear guidance from the courts as to how fairly to approach such negotiations. Lord Justice Nicola Davis, at paragraphs 215 and 218 of the judgment, said pretty much the same thing. What is required is clear and workable guidance by the court, which should enable practitioners to provide legally sound and practical advice underlying the determination of the court is our belief that what is required is guidance which provides certainty and consistency. So I suppose the first question to ask about this judgment is whether or not we've got what we thought we were going to get and what the Court of Appeal in their own comments appear to have been attempting to achieve. And one of the things I think that those of us who are familiar with these claims had always thought, even in the days of the positive discount rate and Robertson and Johnston, was that it was not a one-size-fits-all solution, and that those, for example, with much shorter life expectancies were hard done by. So I think we wondered whether or not some solution could be found that would address those difficulties, as well as the fundamental problem in these claims, which is that if you give a claimant the capital they need to buy the house now, you will effectively be giving them a windfall, or their estate a windfall, when they die. So you are overcompensating them. And that's the central problem of accommodation claims. It always has been. And Robertson Johnston was an imperfect way of solving it. Well, if we ask the question, have we got the clear and workable guidance that we wanted? I think in some cases, yes, but in other cases, a resounding no. And we already know that there is one dissatisfied customer in this appeal, and that is the defendant respondent, who they have already made an application for permission to appeal. They have done so on paper. The Court of Appeal is considering it and is due to give its decision on whether or not to grant permission to appeal to the Supreme Court on the 23rd of October, so that's in 10 days' time. If you were to ask me whether or not they will grant permission to appeal, I suspect not. The case of Peters, which is a case that many of us will be familiar with, seemed to me at the time to have within it questions of principle that were ideal to be looked at by the Supreme Court, but permission to appeal in that case was refused. I suspect that the Court of Appeal will refuse permission, and I suspect that if the application is renewed to the Supreme Court, they too will refuse permission, but obviously I've no real idea. That's just a vague suspicion on my part. I suppose the best way to start here is just with the facts very quickly. The claimant in Swift, age 39, road traffic accident in October 2013. She had a Bologna amputation of the left leg, serious right foot injury. She needed adapted accommodation. The properties concerned are quite eyebrow-raising in terms of their value. I haven't been back to the original judgment, but I remember, I think, that we're talking about central London property here. The value of the property the claimant had was £1,450,000, and the value of the property she needed to buy, £2,350,000, so a differential of £900,000. Mrs. Justice Lambert awarded nothing at trial, saying that she was bound by Robertson Johnston so to do, as indeed had been the previous result at first instance in the JR and Sheffield case. But she granted permission to appeal, and her doing so was later described by Lord Justice Underhill in the Court of Appeal as exactly the right thing to do. The Personal Injury Bar Association intervened, and although the defendants were very keen to control the issues that were going to be dealt with on appeal and invite the Court of Appeal simply to deal with the case as it had been dealt with at first instance when no expert evidence had been produced, even though the claimant was making submissions that Robertson Johnston no longer applied. That failed, and Lord Justice Irwin, I had a look at some of the argument online last year, said to William Audland QC, who's representing the defendant, well, I'm sorry, Mr. Audland, this is going to be the case where we grapple with these issues. And ultimately the Court of Appeal allowed both parties to adduce additional evidence from economists and actuaries who gave evidence on various different topics in the course of the appeal. As we will remember, when Robertson Johnston was in full flow back in the days of the positive discount rate, even then there were discussions about how one might wish to alter Robertson Johnston so as to do away with some of the iniquities that it produced. Various propositions were examined and put forward. There were Law Commission reports, etc. And all of those were looked at, in this case, by the parties and by their experts. But by the time the case came to the Court of Appeal, a number of points had been abandoned. So one suggestion would be you take additional mortgage payments and you simply multiply those by a life multiplier. You take putative mortgage interest and multiply that by a life multiplier. Or you look at rental costs, increased rental costs, and multiply that by the life multiplier. But all of those potential solutions, for one reason and another, were agreed by the parties not to be viable and were abandoned. As was another idea that you could have mortgage interest payments backed by PPO. So in other words, you had a periodical payments order that would pay mortgage interest year on year for life. That was abandoned. And also a loan from the defendant to the claimant with a charge on the property was abandoned. They were all abandoned for sometimes slightly different reasons. But the real problem is that none of these solutions is practical because there simply isn't a solution available on the market for a mortgage to be granted by a mortgage company to a claimant in the situations in which we often find them. And so the parties just agreed that there really isn't any way that those particular proposals could proceed. I hope you'll forgive me if it really is an oversimplification of the arguments that were run, but I've done the best that I can to make it as simple as possible. I have to say that reading the judgment, it's my impression that although it's extremely lucid and clearly explained, particularly by Lord Justice Irwin, unless you'd actually lived for many months or weeks with the expert evidence before you and were appearing in the appeal, I'm not sure that all of the technical nuances come across perhaps as clearly as they might. But I think that's just a function of the fact that the evidence from the actuaries and the economists really was quite complex. But anyway, here's in very broad summary what the parties were arguing on the appeal. The appellant, the claimant, that Robertson Johnston in the negative discount rate world was not binding and it produced an unfair result, that a new approach was needed. That new approach should be simply awarding the capital cost of the difference in property prices from what you actually own and what you actually need, but with a backup that if that was wrong, then what you do is you deduct the market, and I emphasize the word market, value of the reversionary interest. And the reason I emphasize market is for a reason we'll come back to in a moment. So that was essentially the claimant's position. The respondent's position was that Robertson Johnston was binding. Whether actually it was binding or just authoritative guidance, it in fact produces a fair result, even in the negative discount rate world, where you're effectively awarding a claimant nothing for the capital cost of accommodation. And the reason for that, which is, I think, an ingenious argument, is that the claimant will, for now, when buying a property, have to borrow, as it were, from other heads of loss. But in later life, to make up for the fact that they no longer have that money to cover the losses that they have in later life, they can release equity because they own a property. So they can carry out an equity release scheme and use that money to make up the difference. That is how they're going to use the capital asset that they get. And that avoids overcompensation. And it means that there's no windfall effectively, because what they're doing is using their own capital to make up the difference in the money that they didn't have at the beginning of the process. The respondent said, well, even if that's wrong, and here there was obviously a measure of agreement as to the backup position, you deduct the reversionary interest at a fair and reasonable value rather than the market value. And I'll come back to this valuation again in due course. And unsurprisingly, given that they were the defendant respondent, the fair and reasonable value gives a higher deduction figure than the market value. The court's key conclusions: Robertson Johnston not binding, and they distinguish Nower. Nower was the Supreme Court case in which it was held ultimately that in fatal accident claims you take the multiplier from the date of trial rather than the date of death. The date of death was the proposition of legal principle, as the Supreme Court held, that had been enunciated in Cookson and Knowles. And in order to change it, the Supreme Court had to invoke the practice statement from 1966 that allows them to overrule their own decisions. So the Court of Appeal in Swift distinguished Nower and said that was a statement of principle, but actually Robertson Johnston never was. It was only ever authoritative guidance. That the guidance in Robertson Johnston is now outdated and unfair. The particular reason that was relied on by the Court of Appeal judges was that the negative discount rate made it unfair. And I interpose a question at this point, which is, if it's only the negative discount rate that makes it unfair, if the discount rate were ever to go back to a positive figure, would we rewind the clock and go back to Roberts and Johnston? Question, to which I don't have the answer. The respondent submissions on loss and fairness, so in other words, that ingenious idea that a claimant could in later life borrow against the equity in a property that he or she owns, was based on too much speculation and would require actuarial evidence in every case. Now, the Court of Appeal didn't actually make that last point as a reason for rejecting the respondent's submissions, but they made it in passing. And it seems to me to be a very good reason why that argument, if it's correct that you need actuarial evidence in every case, couldn't possibly succeed, because you wouldn't come close to achieving what this whole process is supposed to achieve, which is guidance that can be applied across the board without expensive additional evidence in every case. The court decided that a new approach was needed, and that the way to do this was to award the capital cost differential, so in other words, in this case, the £900,000, and deduct the market, not the fair and reasonable value of the RI, the reversionary interest. Importantly, the Court of Appeal said that this solution may not apply in all cases, and we'll come back to that. So what's a reversionary interest? Forgive me for explaining it in simple terms, really for myself, rather necessarily than anything else, because when I first read it, I had a vague recollection of reversionary interests and trusts and remainder men and so on and so forth, but I really had to remind myself. I think probably the simplest example is somebody who, a deceased husband who leaves a property to, let's say, 2 children, but grants a life interest to his widow to remain in the property. The widow then becomes the life tenant, and the children who will inherit the property later are reversioners or remainder men. There can be circumstances in which the beneficiaries, remainder men, think, well, I don't want to have to wait for mum to die. I would actually rather have some capital now. So they can, and there is, albeit a tiny market for this, seek to sell their reversionary interest on the open market. And sometimes these things are sold at auction, as I understand it. And so the question is, how do you value that reversionary interest? How do you value it so it will raise a capital sum so the beneficiaries can get capital now, which they may want to set up a business or buy a house or whatever. So that's a very simplistic and basic explanation of what a reversionary interest is. And as I say, there is a tiny market for it. And the market was explained to the Court of Appeal by a man called Mr. Watson, who works for a company called Foster and Cranfield, who deal with the sale of these types of reversionary interests. They do about 4 or 5 a year, and that's the only market that exists in the country for the sale of such reversionary interests. So it's tiny, but notwithstanding that fact, the Court of Appeal felt able to base this judgment upon the process that is involved in valuing reversionary interests in those sorts of cases that I've just described. Apparently no one pays tax on this. So the person selling the reversionary interest doesn't pay tax on it, and the person realizing the value of the reversionary interest when mum finally dies also doesn't pay tax on any profit. There's the difference in valuation between market and fair and reasonable. Fair and reasonable valuations are valuations that are essentially arrived at for the purposes often of winding up a trust. So that's really about doing a fair deal as between the beneficiaries if they want to pay each other off. A property might, for example, be valued at a fair and reasonable price rather than what the actual market price would be if it came up for auction. And that was the difference between the two, and the Court of Appeal plumped for the market value rather than the fair and reasonable. Again, forgive me if I'm just making this too simple for those of you who understand an equation that looks like the one on this slide, because when I first saw it, I found myself to be a little bit baffled, because the Court of Appeal talk about a 5% discount rate. So you have the value of the new property, you subtract the value of the existing property, you multiply it by 1.05, so that's your 5% discount rate, and then you multiply it by a minus power, which is the agreed or found or established life expectancy. And I looked at that and I thought, well, how on earth am I ever going to do that kind of calculation? And it's only when I really understood what was going on in terms of our old practice that it began to make sense. You may remember, well, in fact, you don't even have to remember, because if you look at Ogden 8, table 35, there's a table which is entitled Discounting Factors for Term Certain. The trouble with Ogden table 35, and it used to be table 27, and actually before that, back in the day, it was table 37, Discounting Factors for Term Certain. The problem with the current tables is they don't have a 5% column. They only go up to 3%. So you start at minus 2.5%, I think. There's minus 2%, and we go up to 3%. In the old days, and I found an old 2008-2009 PNBA facts and figures on my shelf, the tables used to go up to 5%. So there was a 5% column. Now, we used to use this table for example, if a wheelchair had to be purchased in 40 years' time, we would look at the current cost of the wheelchair, and then we would apply the discount factor from the relevant column. In the old days, it was 2.5%. And we would run down until we got to the row saying 40, and we would multiply the cost of the wheelchair by the discount factor. That's actually exactly what we're doing here to find the value of the reversionary interest. We're just using the 5% table, which no longer exists, but which is about to be reintroduced, and running our finger down to the row where we get to the life expectancy of the claimant, and working out what the discount factor is and multiplying it by the difference between the property required and the existing property. That's what that equation means. Sorry if everyone knew that, but it just helps me conceptualizing what it is we're actually doing here. So we're valuing the reversionary interest, applying a discount factor, which the Court of Appeal has set at 5%. And the damages are then the new property less the value of the existing property minus the reversionary interest. And I have set out there on this slide how the calculation actually works. In fact, if you were doing it by my, let's call it the old-fashioned, old codger's method, you would look down the 5% column in your Ogden table 35 if it had one, and you'd see that the discount factor was 0.1090. And if you multiply 900,000 by 0.1090, you get 98,100, which is as near enough, makes no difference, exactly the same. And you then deduct that figure from the 900,000, and you get to your damages award, as it was awarded in this case, of £801,913. So far, so simple. In practice, I've told you about the 5% table. There are already those smart people in our chambers have already produced Excel spreadsheets which will do this for you. Those of us who use PI Calculator, they've already come up with the software that allows the calculations to be done. I've told you about old editions of Facts and Figures, but actually Harry Trusted, who's on the board of the PNBA Facts and Figures manual that is produced every year, says that that's about to be updated with the 5% table. You can do it, you can do the calculation on an iPhone. There's a guy called Dan Herman at Stewart's Law in Leeds. If you are on Twitter, search Dan Herman, find the right one, the one who's at Stewart's Law in Leeds, scroll down to about tweet number 5 on his list, and you'll see a little video of him showing us all how to do the calculation on an iPhone calculator. That's quite helpful. The Professional Negligence Bar Association have just produced a Ready Reckoner table, which will do the calculation for you. So that's how everything worked in Swift and Carpenter. And I think Miss Swift getting £801,000 against a current need of £900,000, well, I suppose there are arguments both ways. I think the defendants would probably say that's too much, but claimants would probably say, well, that's reasonably fair. But of course it works for her because her life expectancy is 45.43 years. So let's move on to these discussion points and see where we get to. What, first of all, is the status of Swift? Roberts and Johnston, they described as authoritative guidance and not a binding statement of principle, and Swift is exactly the same. Lord Justice Irwin at paragraph 79, litigants and judges at first instance will not depart lightly from such guidance. Cost risks in personal injury litigation represent a formidable discipline, but there would be a diminished risk that guidance as to practice will long outlive the conditions which gave rise to it. And then Lord Justice Underhill, I would add that I agree with Lord Justice Irwin that guidance of this character should only be revisited in response to really significant changes. And in the case of appellate guidance, which it generally is, it will rarely, if ever, be right for that guidance to be departed from by a first instance court. So, and particularly that last extract, paragraph 224, is a really, you know, I can imagine Lord Justice Underhill rapping a sort of virtual gavel and saying to us all, you will not trouble people with this problem again, because we've given authoritative guidance and first instance judges are going to apply it. However, Darrell Allen QC, intervening on behalf of PIBA, persuaded the judges that whatever guidance they gave should not necessarily be strict and should be capable of being altered in the right circumstances. And the Court of Appeal accepted this. And one of the problems they recognised was in relation to those with short life expectancies. Lord Justice Irwin, as I've noted above, we know from the government actuary that the average span of a personal injury claim is around 43 years of future life. And so paradigm 3 represents a case far from the average. Now, paradigm 3, the Court of Appeal had 3 paradigm cases that the parties have produced for them, which are attached to the end of the judgment, which set out hypothetical facts that might assist the argument and developing the argument as it went through. Paradigm 3 is a case with a claimant with a 7-year life expectancy, so a short life expectancy. It may be that different considerations and arguments could be applied to that category of case. I make no further comment on that and should not be understood to express a view on it. And then Lord Justice Underhill, having said all that, I must emphasise that I'm concerned only with a case of the present kind, where the claimant has a long life expectancy. Now, I just pause there to interpose back to the beginning of this talk, where I'd hooked out the passages that talked about clear and consistent guidance that could be applied across the board. And here we have Lord Justice Underhill saying, I must emphasise that I'm concerned only with a case of the present kind. In such a case, the application of a discount rate of 5%, which to anticipate I agree is the correct rate, will mean that the shortfall between the cost of the additional element and the amount awarded will typically be comparatively small. And as Lord Justice Irwin puts it at paragraph 185, the gap between the need and the damages following deduction of the present value of reversionary interest should be capable of being bridged without creating substantial difficulties for the claimant. The position will be different in short life expectancy cases of the kind illustrated by paradigm 3, that's the 7-year life expectancy. As Lord Justice Irwin says, these may require a different approach. So it seems to me that the door is not just ajar, it's wide open. Roberts and Johnston was never fair for those with short life expectancies. I don't think Swift and Carpenter is fair for those with short life expectancies either. And I think the judges in the Court of Appeal expect that in cases of short life expectancy, their formula will not work and will not necessarily have to be applied. And the question then arises, well, when will it be legitimate to depart from the Swift formula because the life expectancy is short enough to mean, and let's go back to that previous quote, looking 5 lines from the bottom, substantial difficulties for the claimant. How substantial does a difficulty have to be before one might think about not applying the guidelines that have been provided for us in this case? Well, what would the different approach be? We're not told, but Lord Justice Irwin says this: if it were to prove impossible here to award a claimant full compensation without a degree of overcompensation, then it seems to me likely that the principle of fair and reasonable compensation for injury would be thought to take precedence. Now, just pausing there, the thrust of this judgment is that had the Court of Appeal not been able to account for the windfall in a way which they thought was fair to the claimant, And in this case, of course, it meant a relatively small reduction from the £900,000 that she actually needed now. That if they'd not been able to do that, I think, reading between the lines of this judgment, they would have awarded the full £900,000. But they thought the reversionary interest deduction was a fair way to avoid overcompensation. And this paragraph at paragraph 210 indicates to me that they may have been thinking that if that had not been possible, if the gap had been too wide between what the claimant currently needed and what she was awarded under their methodology, then they would have gone back to the principle of fair and reasonable compensation and would have awarded the full purchase price or the differential price. But they haven't told us. They've just left the door, as I say, I think, wide open. Just to give you an idea then, had Miss Swift's life expectancy been shorter, if it had been 20 years instead of 45.43 years, the damages award would have been £560,799. That means nearly £340,000 would have to be found from other sources for her to buy the property she needed now. Is that a substantial enough difference, or is that a substantial enough difficulty for a claimant, in Lord Justice Underhill's words, to mean that the guidance wouldn't apply? Well, we're not told. Who knows? It's nearly £340,000. That is a large sum of money. I leave it open. I don't know the answer. 10 years, if Miss Swift's life expectancy had been 10 years, her damages award would have been £347,458,000. That means that she would need to find over £550,000 from her other heads of loss now to buy the property. Would that be substantial enough? I find it hard to imagine a world in which it wouldn't. So had her life expectancy been 10 years, I don't think this methodology would have worked. What the Court of Appeal would have done about that, I don't know. But I think the suggestion is they would have awarded the full 900,000. If we have a really short life expectancy, then we're into 5 years, then the differential is over £705,000. Damages award 194,826. That, it seems to me, I think one just walks through the open door and says to a first instance judge, Swift and Carpenter doesn't apply. How can you condemn this very vulnerable, probably quite young person, or possibly old person, of course, vulnerable with a short life expectancy, to finding £705,000 from other heads of loss that they may not have? Another problem that I think we've identified, is different capital needs. So if you look at the judgment in Paradigm 1, that's a case of an 11-year-old child who would have bought a property age 25 and then another property age 35, and whose life expectancy was to, I think, age about 40 or 41. How do we factor in to the Swift calculation the properties that would have been purchased but now will not be purchased? And I've set out a very simple example there. Claimant 10 years old, needs £1 million now, would have bought a property for £500,000 with a partner at age 35 and rented until then, let's say from age 21, and a life expectancy to age 60. I don't know the answer to this question. The Court of Appeal have not told us. There's no clear reasoning on it, and I have now asked, I think, around 8 to 10 different people, including 2 people who are actually arguing the case in the Court of Appeal, and I haven't had the same answer yet. The best I can do is just to say, well, I think instinctively you take the value or the share in the value. So if someone buys a property with a partner age 35, you take £250,000 and you deduct it from the million and you do your Swift calculation on 750,000. That seems to me to be instinctively the simplest way to do it. If you have 2 properties that would have been purchased, you might take a weighted average between the differential that those 2 properties would produce, and then apply it across the board. But I can tell you that different people have different solutions. Going from you ignore completely the property that would have been purchased to doing a complex calculation where you try and work out the different discount rates and Swift and Carpenter calculations at the different ages at which they would have to be done and then adjust for accelerated receipt. But I can tell you, if you do that in this particular paradigm case that I've given you, you end up with a value of more than £1 million. So it seems to me that can't possibly be right. I do not have the answer to this question. The Court of Appeal has not given us the answer to the question. And when people who are actually involved in the case are giving me different answers as to what they think it means, I think that indicates that there's a problem here that needs to be sorted out. How it's sorted out, I'm afraid I don't have the wisdom to answer that question. Very quickly, other discussion points. Lord Justice Irwin thought that the result of the judgment, this judgment, might be that the reversionary interest market takes off. It's a tiny market at the moment, but I suppose if one has entering into the market a number of personal injury claimants who need to make up a shortfall in damages that they're receiving and therefore need to sell reversionary interests in their properties, a market may spring up. It would have to be a regulated market, and Foster and Cranfield, the only people who provide these interests for sale at the moment, are not regulated to do so, which is a problem which perhaps might be capable of solution. They need to be regulated, just if anyone wants to know, under the Financial Services and Management Act 2000, section 63B. Financial advice claims, I suppose if we're into the territory where a market does spring up, does that lend weight to claimants who are claiming the cost of ongoing financial advice managing their awards? It seems to me as though it may well do. Is Robertson Johnston actually dead? In paragraph 220 of the judgment, I've mentioned this already, really the only reason it was thought the negative rate was the only reason why Robertson Johnston was inappropriate was really because we're now into a negative discount rate world. So if the discount rate were to go back to being positive, do we revert to the authoritative guidance that was previously given in the economic circumstances that existed at that time? The final point I'm going to make, and I'm again not, I'm afraid, going to attempt an answer, but it's in relation to wrongful birth claims. I've asked the question, is the SWIFT method appropriate? I don't think it can be. In a wrongful birth claim, we have an economic loss claim by parents who've given birth to a child who's born with serious disabilities. That child may need adapted accommodation, and the parents may be judged to be reasonably going to provide it for them, and the defendant may have to pay damages. But how is that to be calculated? If this disabled child has a short life expectancy, which is a lot less than the life expectancy of the parents, at the end of the child's life expectancy, the parents have a house, which is much bigger than the one that they would have needed on their own, and it's been adapted for their disabled child. That is obviously an asset in their hands, which has to be taken into account when the damages are initially awarded. And I'm not, but by no means certain that the SWIFT method could possibly do that. And by no means certain that a reversionary interest would be a saleable thing in those circumstances. So I think we would have to look again at how one would value the damages in a wrongful birth claim. So in conclusion, I think that those of us who deal with these claims and will continue to deal with them and negotiate with our opposite numbers in order to try to achieve settlements are pretty much going to be doing exactly what we've been doing for the last 3 or 4 years, which is saying, well, there are a lot of unanswered questions, so we, the defendants, will give you a bit more than we think a straight Swift and Carpenter calculation would give, because we appreciate that there are arguments that could go both ways. We, the claimants, will not take quite as much as the full capital cost of the difference in the property that we actually now need to purchase the property we require. But in short life expectancy cases, we'll want to get pretty close. And so I think this was an opportunity to give us, or at least attempt, a one-size-fits-all solution. It hasn't achieved that. That may simply be a function of the fact that it is impossible to achieve, in which case the only way we'll ever get it is if there's legislation. And with that, I'm going to hand over to Angus, who's going to give us 1 or 2 little bullet points on the defendant's perspective in accommodation claims generally.
Ed, thanks very much indeed. Just a couple of points on your talk. I have to say thanks to Ed. That was as illuminating a talk as I think could have been given in the light of the rather confusing judgment. My personal view, with my defendant hat on, for short life expectancy, particularly of the 5-year category, and I can see it gets more difficult as one goes 10 years, 15 years, 20 years, but I would have thought for 5 years as a defendant, you say you can rent for 5 years, because you do not want to be giving the claimant, let's say it's the £900,000 that we have in Swift, knowing full well that in 5 years' time, that's a windfall, and a big one. And the fair and reasonable point must apply to both parties. It's not unique to claimants. So that's my thought on that. My other thought is the ingenious argument, as Ed characterised it, that one could take equity release further down the road as a claimant, seems to me a perfectly sensible and valid point, and no doubt that will form part of the permission that sought to go to the House of Lords. And the reason I believe it's fair and valid is we have already accommodation experts to tell us the value of adaptations and so on. We have already experts who deal with the costs of personal injury trusts and similar. Why on earth we couldn't have an actuary? And it's a pretty simple actuarial calculation, I would have thought, and one that would be capable of being dealt with by a single joint expert. And indeed, that's the sort of thing that the Court of Appeal could easily have said. We accept that there's an argument that there could be equity release further down the road. That needs to be valued, should be done by a single joint expert. And that's our guidance on that. So there are ways around these things. The Court of Appeal didn't grasp any of these nettles, and there we are. I then turn to a further defendant idea, and I'm going to get Ed to move the slide on for me now, if he may. And this is the peripheral issues. Swift is going to give substantial capital awards to claimants, certainly where the life expectancy is 20 years or more. And what can defendants do to reduce the burden of that? And if Ed takes me to the next slide, please. We come to adaptation costs. And I have certain views, as those who know me will probably already know, and apologies for repeating myself to them. Accommodation experts need to properly focus on the claimant in front of them. There's all too often a pro forma report that's written for the very worst wheelchair dependent person, and it makes allowances for a panoply of things: covered carports, raised flower beds, raised sockets. It might include therapy rooms. And one needs to, as a defendant, to get one's expert to think about these things properly. Is this a person who's going to be going out and about on a regular basis and need a covered carport? Are they interested in the garden? Are they going to go into the garden? Do they need raised flower beds? Are they too ill for the raised flower beds? Are they going to need or use raised sockets for their electric plugs, particularly where they have anyway carers on board to look after them? And the reality is, most of us in our lives, we plug in our lamp or our computer or whatever it may be, and it stays plugged in. But if it needs to be unplugged, there's a carer there to do it. So there are some items that can be attacked. And then if I take Ed to the next slide, I would be, again, very careful with valuing betterment. There tends to be, in my experience of accommodation reports, a fairly blanket, well, we'll give you £10,000 for betterment, or we might give you £20,000 for betterment, but we'll subtract off the money it will cost to put things back. But actually, we've given this injured person a new kitchen, new bathrooms, improved toilet facilities downstairs, a wet room. We've improved the access at the front of the house. We've improved the access to the garden. Now, in real life, if all of us do those things to our houses, we expect to add some value, and the value may not be quite what we spend on our new kitchen or bathroom, but it's not going to be as little as £10,000. It's going to be a substantial sum, and accommodation experts need to be dragged in to think about that properly, in my view. And then if we come to my next slide, this is part and parcel of the same point. But of course, the other thing that happens is one often gets an adaptation which includes an extension to the property, and it may be a very substantial extension. It may be tens or even hundreds of square meters of extension, and if it is, then that must have a very substantial value in the real world. And again, in the real world, if I have a 3-bedroom house and I manage to extend and convert it into a 5-bedroom house, then it's worth a lot more money. Ditto adding extra bedrooms, bathrooms, the improvements to my driveway, to my garden. There should not be beyond the wit or ability of an accommodation expert, not least because there's now so much data available on Zoopla and similar sites, to apply a pounds per square metre or pounds per square foot in old money figure and say we've increased this property by X square metres, that is worth X thousand pounds per square metre, therefore we've added 100 grand or whatever the number comes out at to the value. That again, in my experience, that isn't done at the moment. It should be, in my view. And that concludes my rant on behalf of those who are defendant-minded. And thank you very much, everybody, for listening to both of us today.
Can I, Angus, if just because we can, and if of course people can, log off if they want to. They've got other and more important and better things to do. We did receive 4 questions in advance. I thought I might just run through them, just those 4, and see where we get to. We got one from Janine Collier at Tees Law. What's the best way to approach an accommodation claim for someone with a short life expectancy? I agree with Angus that if it's very short, it's certainly worth looking at whether or not there's a rental solution. But I think once you're into sort of 10, 15, 20 years, I would repeat what I said during the body of my talk today, which I think the door is wide open for you to go and argue that you should get the full capital value. Ella Davis in our chambers asked, how would you approach a claim for a young claimant 20s whose accommodation needs will arise much later in life, mid-60s? I think the answer to that is you do the calculation from the age at which the need arises, mid-60s, and then you do the Swift calculation from that point, and then you adjust for accelerated receipt back down to the current age. Peter Hale at Stewart's Law, do you think there'll be an appeal, and if so, on what basis? Is there still a purchase price deficit for those with short life expectancy? Question 1, the defendants are applying for permission to appeal. I agree with Angus. I think the basis for that, I'm not sure they'll argue that the stare decisis point was wrongly decided by the Court of Appeal. In other words, that Robertson Johnston was actually a binding statement of principle. They may. But I think the more important point that they'll argue is that actually the equity release later in life is not actually so speculative, or at least it's no more speculative than the sort of exercises we do day in, day out for these personal injuries claims. And the Court of Appeal was wrong to reject them as being too speculative, and also potentially wrong to reject them if there is simple actuarial evidence that could be given by a single joint expert. So I think that would form the central plank of any appeal should it succeed in being allowed to go ahead. Carrie Burrows at Drummond Miller, how do you think the court practitioners will deal with individuals who may never have owned property, i.e. rented for life? Well, I think that the correct position as a starting point is if you've got someone who would always have rented and is able to rent now, and that's a big if because the rental market is very odd for these sorts of cases, sometimes doesn't exist at all. I think it is building up, but anyway, then if somebody would have been a renter anyway, then you just claim a differential, and it's possible, in fact, I think probable in a lot of cases, that calculation will produce a higher figure than the capital cost that is required to buy the house outright. In which case, the parties might agree, or the court might impose upon the claimant a duty to mitigate his or her loss and buy the house rather than make the rental-based claim. But the rental market is tricky. We know that there are cases where families with disabled children will rent for 1, 2, 3 years while they're waiting to buy a property. So there is a short-term rental market, but I think once you're into the 15, 20, 25-year mark, the idea that a claimant will be able to rent for that period of time is difficult because one never knows quite what's going to happen to the property, whether the landlord wants to sell it, whether the claimant is therefore vulnerable to having to move and readapt a property in later life, and so on and so forth. I think it's full of problems.
I suppose another potential option is to buy a property on a limited lease. So you've got 20 years left of life. You buy a property with a 25-year lease on it, which is cheaper, of course, than buying a property with a long lease or a freehold property. And in a way, I think that's sort of what they're trying to do with the reversionary interest. But it does occur to me that that might actually work for the shorter term. Again, I'm no expert, and I'm not sure how many short lease properties are available. They tend to be flats, so it may not suit all claimants, but certainly if it's a single claimant without a family, one can see that might be a viable option in some circumstances.
Yes, I would agree that. I think the real point is that there are still lots of unanswered questions which may only be answerable by practitioners thinking anew about the sort of problems that are going to arise and obtaining the evidence to deal with those problems and obtaining permission to rely on it and calling it if necessary. I think really all we're doing is repeating ourselves when we say that this judgment leaves a lot of unanswered questions. Should we leave it there? Thank you, everybody, for attending.
Thank you so much, everybody.
And
Cheerio.
goodbye.
Thanks.